I'm Drew Stevenson, and this is a lecture for my administrative law class about the Freedom of Information Act. And specifically here, we're going to be talking about FOIA Exemptions 5 and 6. And for my students, once again, the most important thing to learn about FOIA are the 9 exemptions. That's what all the litigation is about, is an agency doesn't want to disclose the requested information, and so they have to invoke one of the 9 exemptions, and then we end up with a court decision about whether that exemption applies or the scope of it. And for my students, instead of like reading through the cases in your casebook and puzzling over the reasoning in the cases, you really should invest your time mostly on just memorizing the 9 exemptions to FOIA. And that's what I'm going to do here, is talk about 2 of them, 5 and 6, and mention a case or two that help illustrate them. You don't need to remember these cases, but the cases will help give you an idea about how this works in practice and issues that can come up. So here's Exemption 5. Exemption 5 is about interagency or intra-agency memorandums or letters that would not be available by law to a party other than an agency in litigation with the agency, provided that the deliberative process privileged shall not apply to records created 25 years or more before the date on which the records were requested. And so we have an expiration date on this. If it's for old records, you should be able to get those under a FOIA request. But for things that are less than 25 years old, we could protect it under this exemption. And for my students, just keep in mind that within our federal agencies, we have a lot of these documents generated between departments or up and down the chain of command, or between employees at the agency and the lawyers who work for the agency. And there's also a number of kind of formal and informal letters that go back and forth between agencies. In fact, some statutes and executive orders require certain agencies to confer with other agencies and specified agencies in making certain types of decisions. And there's a paper trail generated along the way and about the decisions that happen, and that's what's protected here. So let's take a look. So that's the bottom line for 5 is either interagency, so this is between agencies, or intra-agency, an internal memorandum. And of course, some of these, notice the important caveat: if it's already made available by law to the public or is publicly available, then you don't need a FOIA request to get the document, and the agency won't be able to claim Exemption 5 if you're asking for a document that's part of a FOIA request. So this is an old case. Normally in these videos, I'm trying to give you very recent cases, but this is a pretty famous case. It's in a lot of administrative law case books from the US Supreme Court in 1975. And so I'm going to talk about NLRB versus Sears Roebuck. That's the National Labor Relations Board. And Sears at the time was one of the largest, or maybe the largest, department store chain in the United States. So if you think of the big department stores at your local mall, Sears historically was one of those. A lot of them have closed in recent years, but at the time in the 1970s, they were a big deal. And they were kind of perennially in trouble with the National Labor Relations Board, partly because they were one of America's largest employers. And so Sears, because they were repeat litigators with the NLRB, wanted some internal memoranda, that 2 sets specifically, that it hoped would reveal useful intel about the NLRB's internal litigation policies for bringing enforcement actions. In other words, they wanted to know when a complaint is filed about union busting activities or something else that would come under the NLRB's purview, how does the NLRB decide when to take action and when do they reject the case, the complaint as having no merit? And they were trying to get to the bottom of that, because as you can imagine, if they're litigating against the NLRB all the time, this would be very useful information. And the internal memoranda that they wanted were either between regional directors, were between regional directors and something called the Appeals Council, which was a national um, council where you could review decisions initially, or the general counsel, the lawyers basically who worked at the NLRB, who would communicate. So these are memoranda between regional directors and either the Appeals Council or general counsel about whether to dismiss certain claims. And the big takeaway from NLRB versus Sears Roebuck is that the court distinguished between pre-decisional documents and documents that embody the agency's final decision or position. And imagine, of course, the agency invoked Exemption 5 and said these are interagency or intra-agency memoranda between our regional directors and either the Appeals Council or General Counsel, spelled differently, the agency's top lawyers. And but the court decided that they're not all the same thing and not all of them are covered. So the decisions to dismiss a case or not bring a charge, an enforcement action, were final and were no longer going to be reviewed internally and so forth. And so, and they were binding on the regional directors. In other words, if they were told by higher ups, there is no merit to this complaint, we want you to dismiss it, they would have to go with that. They couldn't then proceed locally to bring in enforcement action. And the court said that those are subject to disclosure, that there's nothing sensitive about the documents if the decision has been made and the file has been closed, so to speak. On the other hand, the appeals and advice memos that were approving an enforcement action were not the final step. And instead, they were sort of just one more step, because the agency could still decide either to bring litigation or maybe to settle the case, make a settlement offer early on, or after doing a little more investigation, decide that the case was going to fall apart in court. And so the agency's position was going to continue to evolve with these appeal and advice memos. And so these are pre-decisional, even though they are made by the same people and in response to the same interagency submissions. And so they are exempt. In other words, if the case is closed, there's no reason the public shouldn't get their hands on that memo. You could redact out party names and so forth. But if the agency is still deciding whether to bring a case, then they are entitled to keep this secure and not disclose it. Okay, let's talk about Exemption 6. Exemption 6, I think, is the more intuitively obvious one. FOIA does not apply to personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Think about it. You can't do a FOIA request and try to get the internal medical records of all the employees of the federal government. So for this one, I actually have one of the latest cases from the 2020. That's when I'm recording this video. And this was from the district court in DC, and it's the Center for Public Integrity versus the Department of Energy. The Department of Energy invoked the FOIA Exemption 6 when it withheld government contractor names and email addresses in response to a FOIA request for reports related to nuclear science and safety. And in other words, the Department of Energy had hired some contractors to do research about nuclear power and safety at power plants and so forth. And someone had done a FOIA request to get the information about these contractors. And the concern was that there's really was serious potential for unwarranted invasion of the contractor's privacy via unwanted attention or harassment by activists who were either opposed to nuclear research or to the government giving out contracts and hiring outsiders. Here's a second recent example, again from the district court in DC. A lot of the FOIA cases regarding the federal agencies go through the district court in the District of Columbia. So this one's from 2019, and this is Horvath versus the United States Secret Service. A Secret Service employee had filed a workplace retaliation complaint and then filed a FOIA request for records about the service's internal investigation into the complaint. And the service invoked Exemption 6, and the court agreed, again, that these are personnel records. They said that in the internal inquiry, the agents doing the investigation, the internal review, had interviewed a lot of employees, some of whom didn't want to be or didn't deserve to be identified as possible witnesses to supposed incidents. So they would be listed as potential witnesses, but they wanted to, some of them were going to say that they didn't see anything and so forth. So the service had already released some information about how it handled the allegations, including a general picture of what the nature of the complaint and the steps it took in response. But the court didn't think that they should have to turn over their interview notes with every employee in the Secret Service. And that concludes our little video about FOIA Exemptions 5 and 6.